Never been there.
I'm ready for a hug for you, though.
I guess I better go ahead and join the
You should.
Everybody hear me okay?
Tomorrow, I think.
Okay, I've got 6 o'clock. Call this November 4, 2025 meeting of the City County Planning Commission to order. We're starting. I'm starting, I don't know about everybody else. We're going to call this meeting to order tonight, folks. I welcome everybody. I appreciate you coming. Thank you for your help as we work through these things. Madam Secretary, please call the roll.
Yes, thank you. David Dixon.
Here.
Kevin Richard.
Here.
Bobby Jarrett.
Here.
Mac Arnold.
Here.
Dickie Johnson. Gary Gibson.
Here.
Kevin Heron.
Here.
Greg Hodge. Stacy Denton.
Here.
Frank Boyette.
Here.
Heather Tays.
Here.
Kurt Hamilton.
Here.
Very good. You got a quorum?
We do.
I'd like to thank the commissioners for coming tonight, too. First item is we need to go in public hearing to deal with the minutes.
Second.
Got a motion and a second to enter public hearing. Any discussion? All in favor say yes.
Yes.
Good, we are in public hearing. I'll entertain a motion to approve the minutes of the October 7th meeting as presented.
Okay.
Motion and a second. Any discussion? All in favor of approving the minutes from October 7th, say yes.
Yes.
Any opposed? Minutes approved. Now I'll entertain a motion to leave public hearing.
Second.
Any discussion? All in favor of leaving public hearing, say yes.
Yes.
Any opposed? We're out of public hearing. The next item on the agenda is the October finance report. Thompson, can I have this for that?
Yes, thank you, Mr. Chairman. In front of you are the October finance reports. We are currently 4 months into the fiscal year, and we're at 37% of budget. I'm here if you have any questions.
Any questions for staff concerning the finance report, folks? Can you all hear me okay? Can you hear us up here? No. This mic's on.
I've got this one, I don't know about these others.
How about that? Yes. Okay. Guess it's just me. I'll have that effect on machinery of all kinds. All right. Back to the finance report. I'll entertain a motion to approve as presented.
Second.
Have a motion and a second to approve the finance report. Any discussion? All in favor of approval, say yes.
Yes.
Any opposed? Finance report is approved. The next item is under administrative business. We have a training session led by our counsel, our attorney for the planning commission, having to do with communications that take place outside of these public meetings.
I'm more than glad to do it now, but I might suggest we move it to the end of the meeting. Your call.
Okay. Anybody have a preference?
It might be helpful to the people in the audience to listen to this.
I second that.
Well, they listen. You want me to do it now?
Let's just go ahead and do it. Thank you.
Can you hear me?
Yes, thank you, sir.
Can you hear me? We're first going to discuss communications outside of a public hearing on a rezoning matter. Communications with you outside of a public hearing regarding a zoning matter, regarding a parcel that's up for rezoning or someone's considering rezoning it, is absolutely prohibited. If someone approaches you and wants to give their opinion, they're against rezoning this or that, or they're for it, and here's why they're for it, and here's why they're against it, please ask them to come to the public hearing, that you and all of the other planning commissioners very much want to hear what they say, but you all want to hear it at the same time. And the people that are for need to be able to hear what the people against say. The people that are against need to be able to hear what the people are for say. If I mix that up, the opposite side has the right and needs to hear what the other side says. When you're sitting in a zoning matter, you're sitting as a judge trying a case, or a hearing officer hearing a matter before them. This is a quasi-judicial proceeding. So discussions outside of the meeting are prohibited, just as you couldn't go, if you had a case before a judge, you can't go talk to that judge in his front yard or at Walmart or anywhere else, or call him or her, call a judge and talk to them about your case. We all know that. We don't try to do it. But people do not understand that as citizens, planning commissioners, when you're hearing a zoning matter, you're hearing a quasi-judicial proceeding. If someone persists and just won't stop and proceeds to give you their opinion and why, and this and that, you can't get away from them. The law requires three things, three things. When the hearing starts, you have to say, I was contacted by this person about this matter, and if the communication was a text, an email, a letter, whatever, you file that in the record and say what it's about. If it's a verbal communication, you're required to disclose it, but the law is very specific. You have to write a memorandum. You have to write what they talk to you about and say it verbally, but present that written summary that you prepared in the record. So takes time. It's difficult to remember what the person said and get it accurate and get it in the record. Now I'm going to switch gears. If you're considering, as a planning commission, a legislative matter, if you're considering working on a zoning ordinance that already exists, creating a new one, creating a subdivision reg, changing a subdivision reg, changing a zoning ordinance, that's not a quasi-judicial proceeding. The law is different than a zoning matter. However, the long-standing tradition, policy of this planning commission is to treat them the same. And there's a good reason. If one side gives you their opinion, gives you information, and the other side doesn't know about it, and that comes out, becomes known, then the perception is that we're not being fair. This planning commission has always been totally above board, fair, and honest. And continuing that policy, in my judgment, is healthy for the planning commission. But the law is not as stringent. It's not as stringent. You should still disclose on the record that somebody contacted you. They give you something in writing, you should put it in the record. And if they talk to you about it verbally, it would be good to summarize on the record, not necessarily put it in writing, but who it was, what they talked to you about, etc. Do you have any questions about either one of those?
Any questions from the commission?
Mr. Friday, as the newest member of the commission, I do have a question. If there's nothing pending, there's no specific request to rezone a parcel of property, there's no legislative issue pending, is it appropriate or inappropriate for we commissioners to have conversations outside of the planning commission meetings about general policies?
It's always permissible to talk about general policies. Where you go to file, where you get the form, how much it costs if you know. Procedure is always permissible. It's hard on some things to distinguish that. Someone says, I want to get my this or that rezoned, how do I do it? You call staff, you go to the planning commission, you get the forms, and you pay a little bit of money. But before you stop talking, say, but you can't tell me about your property and what you're going to do and why. That's different. That makes sense?
Yes, sir. Thank you.
Okay.
Councilor, could you discuss documents?
I'm going to, but I want to.
Good. Any other questions so far? Okay, please proceed.
Documents could mean a lot of things. I'm going to use slightly different terminology. If you send or receive a text, an email, a fax, any kind, or somebody hands you a communication that's subject to being discovered in a lawsuit. What that means is if planning commission files a suit, or the county files a suit, or a citizen files a suit and contest a rezoning, even though it's finally approved by the county and not by us, not by the planning commission, we're probably going to get sued too. And if we do, they can subpoena your records, which means you have to go through your phone, find all the communications, some way, download it, and turn that over to the other side. Doesn't matter if somebody sent it to you, or you sent it to someone else, or you're texting another planning commission or planning commissioner about a matter. It's legal. It's legal. But you're going to have the burden of digging it up and turning it over. Is that the document you're thinking about?
Actually, I was thinking more in terms of presentation type documents, you know, workbooks, facts, research documents.
Those that someone wants to present to you as planning commissioner. It's inappropriate to accept that. Documents need to be presented at a planning commission meeting, preferably at a public hearing, and put on the record. And you shouldn't accept it, then bring it here and put it in the record. Whomever wants you to see it, they're going to want every other planning commissioner to see it, needs to come here, introduce it into the record, it'll be part of the minutes, and then it can be handed out to you, but it can be handed out to the general public. It's public. Is there more that I'm not thinking of that you're wanting me to
I
address?
think, any questions from the commission, any further questions? I think there are such presentation type documents, information sheets, workbooks, what research, whatever you call it, that are in existence, having to do with wind power. And I'd like to recommend that we hold a public hearing next month, so everybody can know what's coming up, so people can bring these types of research materials, presentations, documents, whatever they are, and we'll get them entered as part of the record.
That's the way we
That
should.
would be my recommendation.
It's the way we should
based
do
on what I've heard.
it. It's the way we should do it. And there may be information on, specifically on wind that we're dealing with right now, and going to be dealing with in a whole series of public hearings, starting sometime in the spring, that have been sent to staff, but are not in the record, that haven't been given to you as planning commissioners, and that should be put in the record, then given to you.
Is that something that's doable, Mr. Bishop?
Yes, sir, Mr. Chairman. I think we could put that as a public hearing item. Or worst case scenario is administrative business, but we can definitely do that.
I think it needs, what I'm hearing is it should be classified and advertised in advance as a public hearing, where everybody knows what,
And that's the way we want to do
gives
it.
the opportunity to enter this material, and there may be some things that, you know, we need to catch up on and get them officially added to the record before we proceed. It's a housekeeping matter, I think, but important.
But it's not a public hearing to say you're for or against wind. They're going to be a whole series of those broken down into various aspects, and there'll be some that are general, but to spend 30 minutes or an hour or 2 hours saying you're for it or against it, this is not, that public hearing is not the place to do that.
Yes, I would hope folks could, needless to say, that we'd like to have them describe what this is, summarize it perhaps.
Yeah.
Perhaps the document can be read on its own. Any other questions from the commission?
Yes, one, Joe, if you as a commissioner have got a case coming forward, say such as the wind situation, is it permissible for us to do our own research, trying to understand what is all
Yes.
the makings of that?
Yes.
Okay.
And if you're gleaning specifics when we're talking about it, wherever it fits in which public hearing or in the general one, share that with the commission.
So Tony, let me, I think, to answer Matt's question and what you're saying, what I'm hearing we should, and it's permissible for us to do our own investigation on our own.
Yeah.
But if somebody would approach you and say, here's some information I have provided for you to do your investigation, that we should say, no, please bring that to the.
Correct, 100% correct. Now, what you should not do, if whomever is having their own public meeting to present information, you should not attend that. If they want you as a planning commissioner to hear that, they need to come here and present it.
So,
Any other questions, folks?
so Mr. Friday, just to clarify, no lobbying is the general rule. The public can't lobby us, and if they do, or even try to, provide us with information or argue to us individually, we have to report that to the Planning Commission on these parameters, and it goes into the record for whatever issues before the commission. Simply put.
Accurate, completely.
Thank you. Okay.
If someone did approach you, whatever, that, would you be needing to say, excuse yourself from the vote because feel like you've been compromised?
That's a personal call. If you feel like you've been compromised, absolutely. Or if someone asks you to vote a certain way and you say, okay, I will, you cannot vote on that. You have to recuse yourself. But if somebody just persists and says some things to you, you have to disclose those. If it's verbal, you have to say who it was and that they've approached you, and then you have to also put it or summarize it in writing.
And the intention, the reason for this rather convoluted policy is it's fairness, right? It's so that everybody knows both sides are in between, or if you're trying to make up your mind, we're all getting the same information.
Correct. Precisely the reason.
Glad he did this first.
Any other questions? Council, do you have anything you'd like to add?
No, sir.
Okay. I'll entertain a motion that we have a public hearing in December in order to get wind power related printed materials or presentation materials into the record.
Is that going to be on our normal meeting night?
Yes.
And they're just going to basically dump them here on the table.
Well, they could summarize them.
Yeah, I guess my suggestion is if we motion this, we have
Really
some
should.
speaking rules or ground rules that you're allowed so long to present what your material is, but a long.
Okay.
I would think some kind of speaking rules would apply to that as well.
Well, could we use our regular standard speaking rules, the 3 minutes? Sure. Lawyers speak first, that kind of stuff. Read that at the beginning of that public hearing. Everybody familiar with what I'm talking about?
Are you looking for a second to your motion?
I don't have a motion yet.
So,
I thought you made one.
I'm entertaining one.
Okay, well, I'll make that motion. That we hold a public hearing at the December meeting so people can present materials and make short presentations.
Mr. Chairman, it would be my suggestion that instead of having 3 minutes, everybody gets 3 minutes, then we come back and get another 3 minutes, that you consider expanding it to 5 if you're talking about what you're presenting, to keep it in context. Not, it's your call.
I have no trouble with that. Can we make that part of the motion?
Yes.
That's not part of the motion, that's your.
Okay.
I
I just said short, but 5 minute cutoff is fine with me.
Okay.
So if we do this for materials for the wind energy, the public hearing plan, and let's say someone intends to present something on safety and engineering and infrastructure, would this be the one time that these folks are going to have to present this materials, or are we going to get it again in separate piles again and again and again and again as we go through public hearings on this matter?
I would hope we would not get the same material,
Okay.
but I don't think we can limit at some future point, months from now, somebody's not, I think at that public hearing, they would have the same opportunity.
Mr. Chairman,
I think we're playing catch-up
Yeah.
here.
Well, I think we're talking about two different things, so please correct me if I'm wrong. The first item that TJ and Chairman Dixon would be just information in general, like so for packets that the folks at Cordelia would like to share. That is what the December meeting would be. The plan that staff has prepared would be specifically, like you said, for noise. I think they're two separate issues. Am I understanding that? Am I paraphrasing correctly?
Yeah, yes, but what I want to make sure doesn't happen is that, say, if a citizens group wants to hire an expert witness on these matters, that this is their one and only chance to present evidence in written form for us that we consider later. You understand what I'm getting at?
I don't think that's not my intention. I know what I'm limiting. I'm trying to make sure that stuff that exists already out there, probably some of you all have seen, gets on the record so it can be used as part of the record.
Okay.
But there are going to be specific hearings on noise, on health effects, on, I can't tell you what they are, Brian can. But this is not the time to bring in an expert.
Well, okay, so if an expert has a report on, say, if there is, someone wants to consider some scientific study on northern Indiana windmills and their effect on cattle, is this the time to bring it in now, or are they going to have a chance to do so later?
It's not. It'll be permitted, but it's not the time, because there are going to be a series of public hearings.
Okay.
Dealing with each of those broken down topics.
So what's the purpose of having a time for people to come in and preview their evidence that we're going to hear
Not
later?
preview, I think.
There is information floating around, and there's some in the planning commission office that has not been shared with the planning commissioner because it's not public. It's not public record. It's not part of the proceeding.
Okay.
It's to get it into the record. I know it's confusing.
Well, it's, unless someone is a corporate attorney trying to do this sort of thing, I just want to make sure that everyone that's interested in these things has the chance to, submit their documents and evidence, and it's not just cut off for the one time in a month.
That's not my intention.
There are going to be
Okay.
numerous opportunities.
Mr. Chairman, can I jump in?
Okay.
Yes, sir.
Elaborate on this?
I'm going to be quiet.
I'm sorry, I should be too.
No,
I told you I can't do that very much.
Mr. Ram, I think this will help kind of answer some questions. So staff has provided a draft plan. It is broken into 7 different categories, which you mentioned just a minute ago. And the thought process is because, just like you said, there's so much confusion if we were trying to put all of these experts at one meeting or one series of meetings, it's going to be insurmountable, in my opinion, that we cannot take in and actually understand all the data that's being given to us. So I've gone in and created basically a plan, which is we meet bi-monthly on individual topics that you would see on the sheet that we provided. And the reason why is because my concern is twofold. One is that it will muddy the waters with traditional and normal planning commission business. And the other is that we will burn everyone out if we do it monthly, back to back to back.
Excuse me. Before we move on to the next topic on the agenda,
Oh.
can we deal with the motion that's on the floor? We have a motion and a second to hold a public hearing next month.
Did I get a second? Who second?
I did.
Did you agree to the 5-minute
Yeah.
cutoff? Okay.
in no way are we limiting future testimony.
No, that wasn't my intent.
Good.
For evidence, yeah. Documentary. Do you mind repeating the motion? I don't know if someone wrote it down.
Not verbatim.
Well, remind me what I said.
We made a motion to agree that the December public hearing is to present materials
Yes, and
for
that,
the wind energy procedure of the,
And Commissioner Boyer, using our traditional rules with an extended time up to 5 minutes.
yes. That was the motion.
Clarification to that.
yes, changing the speaking rules from 5 minutes to 3, from 3, 2, 5, from 3.
Our attorney has just tried to help us understand it is best that this type of things be presented at a public hearing that's advertised in advance. Everybody knows this is what's going to happen here. Everybody has a chance to do that. We're going to set this public hearing next month, and folks can bring forward what they have. Maybe there are some things they don't have yet, they're not have in the future, and we're not going to limit that testimony by any means. I feel like there's a lot of this kind of material out there that needs to get on the record so that we can all be aware of it. Both sides. All three sides. That was my intention.
Mr. Chairman, a question here. Are we going to, I know in the past when we've had open discussion and limited time, we had basically stated also, till say 9 o'clock or whatever, and then we reconvene the next night. Now, is this something we're looking at, or are we calling this all just everything convening by 9 o'clock and then that's cut off, or what? I just want to.
Well, we can't limit it that way. I guess we'll just come back the next day. I'm done with predicting things that are going to happen. It doesn't seem to me that would be such a, we hope it wouldn't take that long, I guess, but I could.
I wanted to make sure that we, how we were
Right.
going to look at that.
I think it's pretty much the usual speaking guidelines instead of changing 3 minutes to 5.
Correct.
Like I say, I think there's some things that have already been prepared with the planning commission as the audience in mind. We've had folks come to public hearings with a stack of petitions this tall. I think that needs to be presented to the record somehow. Correct?
Now or later, yeah.
Well, if that's what the December public hearing, that, we can't do this, we don't have a public hearing going on tonight because it has not been previously advertised to the public. Okay, we've got a motion and a second, and the motion is clear enough that we can sort it out.
Correct.
But please call the roll.
Thank you. Kevin Richard.
Yes.
Bobby Jarrett. Yes. Mac Arnold.
Yes.
Dickie Johnson.
Yes.
Gary Gibson.
Yes.
Kevin Herron.
Yes.
Stacy Denton.
Yes.
Frank Boyette.
Yes.
Heather Tays.
Yes.
Kurt Hamilton.
Yes.
Thank you all. Sorry for the rigmarole. The training session, Counselor covered that. Your satisfaction with the training, communication with outside parties.
Motion on it tonight, or no? We'll approve it as.
In the past, we typically do it the next meeting. The planning commission would vote to approve it for continuing education.
Okay, we'll do it that way then. So we're going to move on to the next item on the agenda, which is the Henderson County Wind Energy Public Hearing Plan Draft. Emphasis on draft. Mr. Bishop?
Yes, sir. As I mentioned earlier, this is a draft plan that sets out 5 monthly meetings that would meet the 3rd Wednesday of every other month. The reason why I chose the 3rd Wednesday was to get it past the planning commission's regular meeting. We also have a couple members that are on the city and county BOZA. This gets them out of conflict with those meetings. I believe Mr. Arnold and Mr. Johnson are on their respective boards. And it is broken down into 7 categories. The first category is noise, vibration, shadow, flicker, and tentatively set for Wednesday, March 18, 2026. The second would be health and annoyance impact review, tentatively set for Wednesday, May 20th, 2026. The third item would be environmental and ecological impacts, tentatively set for July 15, 2026. And I neglected to mention these would all be at 6 p.m. in the evening. Item 4 would be land use and siting criteria, tentatively set for September 16, 2026. The fifth item would be safety, engineering, and infrastructure, tentatively set for November 18, 2026. And then regulatory and administrative framework, tentatively set for Wednesday, January 20th, 2027 at 6 p.m. And then finally, post-draft ordinance public engagement transparency, Wednesday, March 17, 2027. This would give us time to break things down into specific sections. And part of the reason behind it is what I mentioned before, burning out the planning commission members, getting us around other dates. But primarily, I think it would help with scheduling experts with specific categories. Because I think if we were to try to have experts on every category at one or a series of public hearing meetings, it's going to be insurmountable to discern that. So the thought process was to give a starting point for the discussion on how we would proceed moving forward. So with that, I'll do my best to answer any questions about the document that staff has prepared.
Brian, were you looking at meeting up here?
Chairman Dixon and I have talked about it's probably not fair to the city folks to pay for police and everything. So our hope would be that we have it in the fiscal courtroom and the courthouse.
I think that would accommodate for people. Any other questions for staff on this tentative schedule of public hearings?
Mr. Chairman, and this is specifically draft. If we get into it and we need more information on topic 1 or topic 2, the planning commission has full discretion to change this and to add, take away. It is your choice. This was just a recommendation to get us started.
I think, we could, a rather lengthy period of time for us to look into the future and plan this out, because who knows what might transpire in the months ahead.
Do you need a motion to adopt this?
This is
Mr. Chairman? Oh, I'm sorry.
Go ahead, by all means.
What is the specific directive from the fiscal court to fashion an ordinance, right, regarding these things, which could be banning them altogether, admitting them in certain areas, et cetera? That's the specific directive we have, correct?
I have the directive in front of me if you'd like me to read it.
I think it'd be useful.
Okay. First of all, the first request was to deal with the moratorium, which we have done, and they have taken our recommendation and approved it. And then they hereby further direct and request that the planning commission, in compliance with applicable laws, hold at least one fact-finding public hearing after notice is required to gather testimony and evidence sufficient to originate a text amendment to the zoning ordinance, which would constitute a comprehensive wind energy power regulation. And then, so they're asking, their minimum is 2 public hearings. One, gather facts having to do with wind power, and the other one is after a ordinance is written and proposed, or to the point of the draft version of an ordinance, to have another public hearing on that. That's their minimum requirement. And then, of course, they would act on a recommendation that would come from us.
And we're proposing
Thank you.
7,
We're proposing, yes. much
7
more.
and possibly even more once you get into the end kind of.
Right. That's why I'd like this to be considered a draft. Once we get into this, we may decide that we can move quicker. We may decide that we need to move slower. We may decide we'd like to let fiscal court have more time to deal with our product. Needless to say, they can make any determination that they wish with whatever recommendation we make.
But it just seems to be such a long period of time. That's, I think that, I'm guessing that the businesses who want to come here want a quicker decision than this. And certainly the public that's here, been here at all these meetings, want to have a quick decision. Yes, we want to have a thorough hearing, but it shouldn't take 18 months, I don't think. If we could, I don't know how to move it up some.
We have a
It's not
two-year
18
moratorium
months.
right now.
The moratorium is for
Right.
2 years.
Right.
So the first would be March of '26, and just the draft that was presented would be March of '27, which is 1 year, and still gives us time to, so it's not 18 months. It's
Okay.
little over 1 year from start to finish, which is well below what fiscal court approved from our recommendation.
Okay.
No, that's a good question, though, and that's why, I think we need to look at this as a working document, It may not take us that long to become experts in wind power. As you can, if you look at these topics and the descriptions of what kind of information we're looking at, it gets pretty complicated. That being said, I think there's an opportunity to, at some point down the road, to move quicker perhaps, and let fiscal court have more time to do their, their due diligence. In any case, I wanted to share this draft schedule with the entire commission just for this purpose, so that everybody could get a chance to react to, what might be coming down the line. And maybe, we're open to suggestions if folks have a better way to start it. I think maybe we should look at this as just a way to get this thing rolling. I think we all agree we want to get it rolling. In any case, any other comments from the commission?
Well, like you said, we have to have a plan to start. We can always adjust as we go if we feel we're going too fast or too slow.
Is everybody comfortable with the early stages of this plan? I think we've already approved a public hearing for December having to do with this topic. It's not even part of this plan yet. And then the next time, the next public hearing according to this would be March 18th, having to do with noise, vibration, and shadow flicker. We've tried to put the most, I don't know if you could say important topics first, but I think there's some that are more important than others. Commission have any further comment on this? Do we need to vote to start this process, or can we just go ahead and say we're going to start this way unless there are objections?
There's no requirement to vote, you all can. You're just, if you vote on it, you're going to have to vote again and change it. If you don't vote on it, you can talk about it informally and change it.
Anybody have a preference?
No vote. Let's keep it flexible so we can move it up. That's my
I agree. I think we should remain a little flexibility there.
Okay, so unless there are objections, we're proceeding
Public wants a
with
vote, just so you know.
Yes.
Excuse me?
He said the public would like to have a vote.
Sir, here, please come to the mic and give your name and address.
What?
the draft
This is
plan.
not open for discussion right now. It's- Public is welcome to be here to listen, but you do not have the right to participate unless and until the chairman grants you that right.
Is it the sense of the commission that we can proceed without a formal vote here to keep ourselves flexible as we move forward? Yes.
Yes.
Okay, I think that's what we're going to do.
Vote on the schedule. Mr. Chairman, we're just voting, we're just talking about the proposed schedule.
Yes, not the
Not
content.
anything other than that. Okay. Thank you.
Good. Mr. Bishop, you have anything else in regard to this schedule?
No, sir.
Okay. Okay. Next, does the commission have anything that they'd like to share on this matter? Very good. The next item on the agenda is other business. Do we have anybody here who has something else they'd like to bring before the commission tonight? Yes, ma'am.
This would be the time.
Yes, ma'am. I'll need your name, of course.
Of course. My name is Deirdre McConaughey. Address, I swear to tell the truth,
What's your address?
10512 Airline Road, Henderson, Kentucky.
And you do promise to tell the truth, the whole truth, and nothing but the
Yes,
truth?
yes, I do.
Very good. How can we help?
Well, tonight, I thank you for the time, Chairman, and for all the commissioners. I am here tonight to provide to the commission a letter prepared by my attorney addressed to the commission, and I'm requesting that the planning commission staff read this into the record. And I will be available to answer any questions or see what you want to do as far as any discussion or forward. But with your permission, I will give it to the planning staff to read into the record. And I've made a copy for each commissioner so you can read along with them. May I distribute that?
I already have a copy. Is this different from the copy we already have?
Yeah, I got it.
I didn't know it was distributed. You got it?
Yeah, I did it just in case to make sure we had enough copies.
Well, if you need extras.
Maybe some folks in the audience would like to.
Well,
Is there, and this just, again, as a rookie, Mr. Friday, is there a reason why it has to be actually physically read versus just accepted under best evidence rules, and made a part of the transcript?
No,
So we can read it.
requested.
Okay,
It's up to the pleasure of the finance.
okay. I didn't know if there was a
There are people
specific,
in the audience that might like to hear it.
understood. I mean, it's lengthy. Can you please kick me? Next time I don't find
Okay. I think we're going to have to read this. Brian, would you like to?
I will give it a shot.
Okay.
This is addressed to me at 1990 Barrett Court Boulevard, Suite C, Henderson, Kentucky, 42420. Dear Planning Commission members, I have I've been retained by Deidre McConaughey to submit this letter in support of her request that the Henderson County Planning Commission recommend that the Henderson County Fiscal Court enact a 2-year moratorium on battery energy storage systems for Henderson County. On November 19, 2024, County Judge Executive and Magistrates held a green energy workshop to discuss the future of industrial renewable energy projects in Henderson County. Discussion focused on the issue of whether there existed a need for moratorium on all renewable energy projects. During this meeting, the attorney for the fiscal court, Steve Goat, stated explicitly that a moratorium for all 3 energy projects, solar, wind, and BESS, was allowable. Indeed, the legal authority for Kentucky counties to implement moratoriums comes from their planning and zoning powers granted by Kentucky Revised Statute, KRS, Chapter 100, Sections 100.111 through 100.211, which authorize local governments to regulate land use and suspend permitting where necessary to protect public welfare. At the time, Mr. Gold recommended that Henderson County consider each moratorium on a project-by-project basis. The fiscal court followed his advice and approved specific moratoriums for solar and wind. A brief history of how and why the moratoriums for solar and wind compared to BESS show why this is so. An ordinance regulating industrial solar projects in the county was approved on December 23, 2019. Phase 1 of this project included the placement of more than 400,000 solar panels across approximately 1,680 acres in Roberts, Kentucky. Problems identified in the construction of this project proved to be significant enough for Henderson County Fiscal Court to develop a 2-year moratorium for all solar permitting in the county concurrent with Phase 1, construction Phase 1, to become operational on February 10, 2025. The 2-year moratorium for all industrial solar was approved by Fiscal Court 1 day later on February 11, 2025. The rationale for the moratorium stated that Henderson County Fiscal Court has concerns about the sufficiency of existing regulations on level 2 solar installations based upon observations of level 2 solar projects being constructed under the current ordinance, including but not limited to a deleterious effect upon effective water drainage, glare experienced by drivers on roadways, potential insufficiency of vegetation buffers, and potential damage to public roads. No ordinance currently exists for industrial wind projects, but corporate development plans for wind projects in Henderson County are underway. In preparation for writing an ordinance for the wind, the fiscal court took the proactive step of submitting a one-year request for a wind moratorium to the Planning Commission. The Planning Commission returned a recommendation to the court to extend the length of this moratorium to 2 years. The fiscal court approved recommendation on October 28, 2025. Today, Dr. McConaughey is requesting a moratorium on all BESS projects and installations that is consistent with the moratoriums approved for industrial solar and industrial wind projects. Like the industrial solar and wind moratoriums, a moratorium on BESS will allow Henderson County sufficient time to study and review all aspects of the siting, regulation, and impacts of BESS projects that were not sufficiently studied during the development and approval of the current county ordinance for BESS. The county BESS ordinance was based on an ordinance developed by the city of Henderson that was approved in the fall of 2023. On July 2nd, 2024, County Judge Executive presented a proposed county ordinance to the Planning Commission, arguing that the county ordinance mirrors the city ordinance and had already been approved, therefore should also be adopted. The BESS ordinance that the County Judge Executive submitted to the Planning Commission for the county consisted of 7 pages, a fraction of the technical details and protective measures that are typical for an industrial scale project involving lithium ion or comparable battery technologies. A BESS ordinance for the county was approved by fiscal court on August 27, 2024. In a letter from County Judge Executive to the City County Planning Commission, the Henderson County Board of Zoning Adjustment, and the County Fiscal Court on September 16, 2024, the judge stated that in a broad sense, the ordinance was pretty comprehensive, but purposely stopped short of dictating emergency response techniques. To address safety concerns, the judge formed a task force that produced a document for use by governmental bodies titled Battery Energy Storage System Recommended Safety Guidelines. The recommendations produced by the task force are suggestions and not legally binding. The city BESS ordinance that served as a model for the county ordinance has failed. The requirement for approval of conditional use permit for the BESS project was denied by the City Board of Zoning Adjustment on November 20th, 2024. Efforts to cure problems associated with the project were unsuccessful. And in October of 2025, General Manager of Henderson Power and Light, Brad Bickett, stated that the project was tabled indefinitely and that Henderson's leaders are not interested in pushing forward with all BESS given the public sentiment in opposition to BESS. Indeed, community awareness of BESS project has grown exponentially since BESS ordinance was approved. A BESS ordinance is necessary to allow citizens previously unaware of risk associated with BESS facilities the opportunity to have their concerns heard and participate in the revision in current ordinance. If it is also found lacking in protection for the citizens during a BESS moratorium, community involvement is a core component of the Henderson County Comprehensive Plan, with robust public participation built into the process of creating and implementing development strategies. This reflects the widely held planning belief that initiatives are more broadly supported and sustainable when community members are engaged in the decision-making process. A BESS moratorium is necessary to ensure our fiscal court planning commission comply with the mandates of the county by including citizens in review of the current BESS ordinance. 2 recent events made very real the validity of citizen concerns. On October 6, 2025, a chemical fire in Newburgh, Indiana triggered a shelter-in-place alert for multiple counties, including Henderson County. And on September 16, 2025, a fire at the Roberts, Kentucky solar fields in a dry inverter required first responders from multiple volunteer fire departments to respond and monitor the fire for 24 hours. The result of these 2 events has understandably heightened the awareness of citizens that bad things can and do happen. The known fire and toxic chemical risks associated with BESS merit research of the current battery technologies and the inherent risk of BESS. A moratorium is the appropriate place, and now is the appropriate time for this research. The development of BESS is rapidly evolving. relevant best standards providing National Fire Protection Association, NFPA Standard 855 provides standards detailing the requirements for mitigating the hazards associated with energy storage systems, ESS. The first edition standards were published in 2020. The current edition is from 2023. The next update of standards will be in 2026. Significant changes in the 2026 NFPA edition will include improvements regarding safety and the installation standards for BESS, key updates that focus on hazard mitigation analysis, expanding testing requirements, explicitly covering more battery chemistries, and strengthening emergency response planning. The Underwriters Laboratory UL 9540 and 9540A also assesses standards for energy storage systems and equipment, including study of charging and discharging procedures, fire protection and test methods for BESS. The first edition of UL standards was in 2016, and the current edition was revised in 2025. Our BESS moratorium would allow Henderson the time to incorporate the best standards available now and forthcoming regarding fire safety and hazard mitigation. A search for best moratoriums today is replete with examples from multiple jurisdictions nationwide that have taken this cautious step to assess the future impacts of their locales. The Pacific Northwest Laboratory, affiliated with the Department of Energy, reviewed instances of best moratoriums for a period 2021 to 2024 and found that best moratoriums are a recent and increasing phenomenon. Acknowledging that science and governmental regulations will continue to change to keep up with the rapidly evolving scientific standards of BESS, projects mean that Henderson County must be prepared to revisit, review, and change our own standards. The time for that analysis is now during a moratorium for BESS projects. Much uncertainty currently exists that would support the need for a BESS moratorium. Two specific concerns. One, the future of energy generating projects in Henderson County, and two, the availability of federal subsidies that have supported the influx of renewable energy projects nationally. BESS projects are for storing energy that are not produced and do not produce any energy. So given the scale and permitting will be in the future regarding generation of energy for storage, amendments to the solar ordinance and particulars like the to-be-written wind ordinance could be restrictive enough to eliminate the necessity of a massive or multiple smaller BESS facilities. In addition, the current turmoil over removal and governmental subsidies for green energy projects increases considerable uncertainty about the viability of energy companies to construct and operate over a 30-year period with decommission of projects with secure bonding in place to protect the county. That matters to me. Conclusion. Each of the three renewable energy projects being constructed or developed in Henderson County, solar, wind, and BESS, share inherent risk in varying degrees regarding fire safety, land use of farmland, negative impact on residential, agriculture, and tourism economics, environmental contamination from toxic chemicals affecting soil, water, and air, threats to wildlife, possible negative impact to property values, infrastructure damage to the county, and aesthetic industrial intrusion that is not compatible with the harmonious development in the role and visions of Henderson County. All three renewable energy projects fundamentally share all of these concerns, serious issues that have not been studied to date with the scrutiny required. The Fiscal Court and Planning Commission have addressed these concerns appropriately by approving moratoriums for solar and wind. Given that there are identical public safety, welfare, and land use concerns associated with BESS, now is the time to extend the same protective consideration of BESS development that has been granted for industrial solar and wind projects. Based on the information provided, Dr. McConaughey requests that this commission recommend a moratorium on the filing, processing, review, and acceptance of any applications for rezoning, conditional use permits, building permits, or other types of applications for BESS installations for 2 years up to the including December 31st of 2027. Signed, Lorraine White.
Thank you, Mr. Bishop. Good job. Any kind of reaction from the commission?
Yes. This should be presented to the Henderson County judge, not us first. No. We base our movement on what the county and what the city is doing. We don't set the law.
Thank you. Any other reaction?
follow whatever the procedure is because we certainly want to make that accurate. And if that is what the Planning Commission says, then what I should do is take this letter to the fiscal court and begin the process there and then come back and see you again. Is that what I'm hearing?
May I ask a question, Mr. Chairman?
Sure.
Does Ms. White have a Kentucky lawyer's license?
She's been vouched for by a local attorney.
I couldn't find her in the roll of lawyers in the state of Kentucky. She doesn't have a license?
She's not in Kentucky, she's from Indiana.
I don't, as a lawyer, that's just information that I think the chair should know.
It's on her letterhead, and I went through the procedure where I hired a local attorney, Dane Shields, and he has vouched for her to act on this matter.
She's not licensed in Kentucky, from what I could tell.
This is a
So,
common procedure. As a
I
lawyer, you
understand.
know this.
I don't think lawyers appear in Kentucky courts without, or these procedures. Maybe I'm new, so.
Commissioner, this is not a court.
Understood, but this, I just want the commission to know that I don't think she has a Kentucky lawyer's license, so.
I
That's
agree.
it.
And that's why I went through the proper step of hiring 2 lawyers, 1 local, to vouch so that she could act in this matter.
Can you appear pro hoc vice in this sort of matter?
Yes.
Thank
Okay, you're
you.
gonna have to help me on that one. Yeah.
It's an Italian dish.
So what's it mean? Wait. I get what it means. This will get that. Okay.
This is not a zoning matter that you're acting as a quasi-judicial proceeding.
I understand.
She's making a request that you structure an ordinance, and it seemed like where Gary was headed was to make a motion to refer this to.
Well, it should go to the county first, that's who we represent.
Respond to us if it's something.
That's entirely satisfactory. You know, as we all, many of us here, I've been here before, but trying to keep track of where you start and how to expedite and work through the process. So if I need to go to fiscal court, that's exactly what I'll do. And then we'll see what they do with it, and we may see this again. But I, in the spirit of us having done moratorium requests and having hearings about moratorium, I may have misjudged that this would be an appropriate time or place to begin this process. So if that's what seems the appropriate thing to do, then that's what I'll do.
It is appropriate to make a request to this body.
Yes.
It is.
I think that should be clear to everybody.
Mr. Chairman.
Oh, that's-
Absolutely. I don't disagree with that. I just don't, I mean, we submit a letter and spend 20 minutes reading it from a non-lawyer.
Mr. Chairman, may I jump in?
And you so interrupting everybody. Come on, man.
Relax.
Zoning text amendments, and Mr. Friday, please correct me if I'm wrong, zoning text amendments can originate with the Planning Commission or the fiscal court. It has been our policy that zoning text amendments originate with the fiscal court in this regard because they are the elected officials. They are the ones who set policy for the county. That's not to say it cannot originate here. It's just not what we've done, at least since I've been director in the last 10 years or so.
Okay. Any other reaction from the commission?
May I address one?
Yes, but by all means.
Deidre, if you use this attorney to represent your, ask Dane to, you said you'd employed him, ask a Kentucky attorney to put a cover letter.
That's a great idea. He was copied on this. I just want to assure you, but you're right. I can do that easily. That's a great idea.
Thank you. That's all I'm asking.
Okay. I think that would address your concern.
Because it might not be understood
Yeah.
if someone comes in to a zoning proceeding, then
Well,
a lot of people are not going to understand the difference.
and can I also say, I understand, that's a wonderful idea, and I'm learning the procedure too, because having 2 attorneys trying to figure out, and I also expect at some point you'll get to meet Lorene, but since she would have to travel and there is expense, and I'm just one person here, we have been trying to do some of this work whereby she doesn't have to make that travel. So we'll work it out, and I think that's a great idea.
Commissioner Hamilton made a good point.
Yeah, no problem.
Yeah.
Any questions?
Do we need to make a motion and vote on recommending that this request go to fiscal court?
It's probably a good way to get it up there.
Okay. Commissioner, would you put that in the form of a motion?
Yes, I would.
We've got a motion to recommend to this witness that she takes this request to the Henderson County Fiscal Court as a first step. Is there a second? Second. We've got a motion and a second. Any further discussion? Madam Secretary, please call the roll.
Kurt Hamilton.
Yes.
Heather Tays.
Yes.
Frank Boyette.
Yes.
Stacy Denton.
Yes.
Kevin Herron.
Yes.
Gary Gibson.
Yes.
Dickie Johnson.
Yes.
Mac Arnold.
Yes.
Bobby Jarrett.
Yes.
Kevin Richard.
Yes.
Very good. Motion passes. Thank you very much. Thank you very much.
Thank you to the whole commission for your time, and
I think that's a good. Yes, sir. Your name, please.
James Franks,
Address.
2301 Toy Ann Boston Road, Henderson, Kentucky.
You promise to tell the truth, the whole truth, and nothing but the truth.
I do.
How can we help you?
Well, I would like to thank you for your time tonight. Thank Deidre Conti for this letter, and I appreciate what she's doing. I come before you back when you considered the BES ordinance, you can remember, and I shared with you my concerns, as did other members of the fire community. I wanted to reiterate, as the elections come, I am a volunteer fireman who himself just recently found out that I haven't met the criteria to continue serving my community. We're required continuing education, just as all of you are. So the community is served mainly by volunteers, as you're aware. And it becomes so apparent to me this week that we're so busy with our own jobs and our own lives, how those resources are stretched so thin. We had that horrible explosion in Niagara where those folks were hurt, as you recall. 14 volunteers, me being one of them, responded to that. Now, just thinking about that, I wanted to share with this board, I don't know, as you just directed Ms. McConaughey back to fiscal court, my understanding was that those amendments and changes could happen in either body. I'd like for some thought amongst yourselves to be put forth to the county's safety and infrastructure. I was looking at the county's vision and the overall safety plan, and there was things mentioned in there like being thoughtful of land use, and these huge infrastructure projects, they really cause some concerns for me when it comes to the safety of the residents and those responders that are going to be responding to these potential events. So thank you for your time and considering the scale of the project coming forward. I think it's going to be very important. I myself plan to bring documents. I am not going to be able to dump them all next December, so I thank Mr. Hamilton for making it clear that we're going to have multiple times the public that's going to be necessary. I'm not going to take a lot of your time, but I wanted you to know that as a volunteer fireman, as a community member, I appreciate what you do. I know that this is not what you signed up for. None of you signed up to deal with the stress that you're under, but you are appreciated because this is our community and we all have rights. We have rights to use our land to make money, but we have rights to enjoy our land for what we bought it for as well and do so safely. So thank you for your time, and I just wanted to share my comments.
Thank you, sir. Appreciate it. Anyone else have something they'd like to bring forward this evening? Anybody, the commission have something they'd like to bring forward?
Well, should we all extend congratulations?
Maybe we should. Go ahead.
Maybe we should. I think I would like to get it on the record that the entire planning commission congratulates our assistant director on her recent marriage.
Yay.
Thank you, Commissioner. Good idea. Anybody else have anything else? If nothing else is coming before us, I'll entertain a motion to adjourn.
So moved.
Second.
Got a motion and a second. Any discussion? All in favor of adjournment, say yes.
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 Any opposed? Stand adjourned.
Okay.